Good evening, everyone. Welcome tonight to the Judge Guido Calabresi Fellowship in Religion and Law. Judge Calabresi is sitting for a case in New York right now and is unfortunately unable to be here tonight, so he sends his deep regrets. Our speaker, George O'Brien, is a shareholder of Littler Mendelson P.C, a U.S.-based law firm that handles labor and employment litigation, as well as global mobility and immigration issues. George O'Brien earned his bachelor's from Princeton University and his law degree from the University of Connecticut. After law school, he served as a clerk in Washington, D.C. for Chief U.S. District Judge T. Emmet Clarie. He has litigated cases and practiced labor and employment law for more than 40 years, the last 16 with Littler Mendelson, the world's largest employment law firm. George O'Brien attended the East Haven Public Schools and Notre Dame High School, Princeton University, and the University of Connecticut, where he was editor-in-chief of the Connecticut Law Review. So he gave us some hints from his original time at STM here, where Chaplain Richard Russell welcomed him to STM when he was in college, and he and his wife Peg have been part of our community ever since. After the talk, there'll be time for Q&A, so please just come forward to the microphone. And now George will address the topic of working for the railroad, unscholarly lessons about faith and labor law. Welcome, George.
Well, thank you all for coming. I hope that you won't be too disappointed. This is one of those situations where this isn't my usual gig. And it comes about because, and I was thinking that it came about because Sister Jen asked, and she was scraping the bottom of the barrel. But she asked insistently, and this was what she asked: something about employment law and something about faith. So have you tried saying no? A nun even off the bus is very persuasive. So we came to a deal that I'm going to do this. And if it's really terrible, I remind you of the phrase that the nuns used to use in elementary school when they still taught there: offer it up. I'm going to move over a little bit here. And I think the honor of this for me is the name in whose lectureship this is. Guido Calabresi is the gold standard for a lot of things. A scholar, which I'm not, obviously a teacher, the writer of very influential analyses, law school dean, federal appeals court judge, and a bulwark of this community for many years. He's also an influencer, and I'll describe why that is in a second. But you might wonder what a crazy title I gave this thing, and that was because Jen needed a title early, and I think I was being a little flippant. But it's unscholarly because I'm really not a legal scholar. I'm a practitioner. I work from the trenches. I deal with the application of the concepts rather than a kind of top-down analysis. Lessons, I'm not giving you lessons tonight. I'm just sharing some lessons that I've taken from the work that I've done. Labor law, I was really meaning labor and employment law, and I'll try to explain to you a little bit about why there's a difference. Faith, we'll see how that works in. That was really because that's what Sister Jen wanted. And working for the railroad. I started law school twice. I was a newspaper reporter before I went to law school. And the first time I started law school, it was in the evening. And I went to the torts classes, and there was a woman who was the superstar in the class. She was a bit older. She was from out in stores. She came in, she was well dressed, she was well spoken, she was really something to see. And we were reading about those railroad cases that involved claims against the railroad. And the tort professor had described what the liability question was, and he said, okay, Miss Jones, you're the lawyer for the railroad. Tell me what your best argument is to avoid liability here. And she said, I can't do that. And he said, of course you can do it. Make a noise like a lawyer and get up on your feet and you tell me what your argument is. She said, no, I refuse. And he said, why? And she said, I would never, under any circumstances, represent a railroad or another oppressor. I didn't have that much of a quibble about it, so I have represented railroads. And I don't think they've been oppressors, but I have represented employers as well as some plaintiffs and even one union one time during the career. But her notion always stuck with me that that she just wouldn't have anything to do with them. But I've been working for the railroad as well as sometimes on it. Labor law really refers as a term to the federal statutory provisions of the National Labor Relations Act, which is formed from basically 3 enactments beginning in 1935 and a few others added on to it. And also the state law counterparts, which deal with employees who don't fall into the area of interstate commerce or not covered by the NLRA otherwise. So that would include state and municipal employees, people who are on in small employers that don't really affect interstate commerce. Employment law in Connecticut, now this is the distinction between labor law and employment law. Employment law in Connecticut was categorized as master and servant right up until the late 70s. If you looked at the digests, which were then in print, master and servant was a very descriptive term for what those cases said. They accepted the at-will employment doctrine almost literally. The one exception was if you had a written employment contract, it could be enforced. But the notion of there being a separate employment law didn't really exist until the 70s. There was, since 1964, curtailment of the employer's right to discriminate against people. And so Title VII of the Civil Rights Act did ban discrimination based on race, color, religion, sex, and national origin, and it really applied to the general categories of actions that employers could take. None of those could be based on the prohibited characteristic. But limitations on the at-will rule started to be developed by the courts. And one of the first cases was a Massachusetts case called Fortune versus National Cash Register that was a 1977 case. And what happened there was the employee, Fortune, was a salesman, and he had been on the verge of making a sale that was going to pay him a huge commission. And somehow somebody decided it was the time to fire him. So he brought this action, and ordinarily it would not have prevailed because he could be fired at will. But the court in Massachusetts decided that because there's an implied covenant of good faith and fair dealing in every contract, including oral contracts, that Fortune could bring this lawsuit because one party can't wrongly kind of cheat the other party out of the benefit of the bargain that contract represents. And this was a bigger deal for those of us who were practicing at that point than is easy to imagine today, because it really broke with the master and servant concept. the limitations then got extended in Connecticut by a 1980 case called Sheets versus Teddy's Frosted Foods. And Sheets was the quality control manager, and he complained that the food and drug laws were not being followed, that there were unsafe products being made because of that. And amazingly, he got fired. He sued, and he claimed that because there was, in this case, a statute that represented the public policy of the state, and that was something that the company violated by firing him, that he had this right to seek damages. The trial court threw it out because of at-will employment, but the state Supreme Court said, no, we buy this. We buy this concept. And so if there is a public policy, and there was an argument at the time about whether it had to be embodied in a statute or whether you could find it somewhere else. If there's a public policy and it's violated by the discharge, that's a wrongful discharge, it's actionable, somebody can recover damages. These things happened within a decade of one of Judge Calabresi's major publications. And so that's what I meant when I said he was an influencer. He put out a book in 1970 called The Cost of Accidents, and it was one of the first books. It followed some articles that he had written, but it really was a landmark in the law and economics movement. And it analyzed what the effect of the tort system was on the people who got caught up in auto accidents, and concluded that having to spend a lot of money proving whose fault it was and how much damage was incurred was very wasteful. Now, astonishingly, somebody in the legislature heard about this, and it inspired what was called then a basic reparations benefit and no-fault insurance statute. And the basic reparations benefit said, you have to buy a policy for this BRB coverage. So every driver was required to have it. And it paid the driver if he or she was injured in an auto accident, regardless of who was at fault, up to a certain limit. And that driver was prohibited from bringing a lawsuit in the tort system unless certain threshold requirements were met. And they were very low. It was $400 in medical bills. Well, even back when this happened, you walked into the lobby of a hospital and you incurred almost $400. So there was a real question even then about whether any lawsuits were going to be kept out of court. But it was something that had another perhaps unintended consequences, and that was that the guys who made their money on fender benders and whiplash cases in the tort bar, and it was sort of the low money end of the tort bar, they were alarmed by this notion that drivers were dealing directly with insurance companies and cutting out the middleman. They were not happy about exactly what Judge Calabresi had been trying to accomplish. And so when the dust settled, they found employment law. They found the covenant of good faith, and they found the notion of wrongful discharge in violation of public policy. And there were hundreds of lawsuits filed, and the trial lawyers had seminars teaching each other about the best way to bring these claims. And I think that in some sense, Judge Calabresi's influence and the adoption of the BRB system really pushed the development of that employment law. Since then, we've had not just case law development that has expanded what's meant by public policy and so forth, but we've also had a lot of statutes passed that you would call employment law statutes that provide employees with a grievance for some right of action. So he was indeed an influencer. Let me talk about St. Thomas more. The guy on the left in the front was Father Richard Russell, the tall guy. And this is from the recent history that was put out. I met him in 1967. STM ran something called the Newman School of Catholic Thought. It was a series of seminars and talks over the course of several days. College students from throughout the Northeast were invited. And there were more than 100, it might have been nearly 200. And we were housed at Fairfield University in the dorms, really luxurious. But I met some amazing people there. The prior chaplain, Father Healy, who was then studying psychotherapy, talked. Father Russell talked. Richard McBrien talked. There were some other priests from local seminaries that talked. And there were a bunch of friars, Franciscan friars, who came from a seminary up in Massachusetts, and they had a singing group. So the singing friars were there. And I met a lot of the singing friars. And it led to lifelong friendships that I've had with those people, and they've been very rewarding. When I got back to New Haven, I came to STM for Sunday Mass the next week, and Father Russell saw me. He took me aside. He said, "You want to go out to breakfast with us?" After the morning Mass, he and his coterie used to go to breakfast at the Pancake House. So I started going to the Pancake House, and so I was the beneficiary of tremendous hospitality from Father Russell, and just met, besides the folks from the symposium, I met folks who were part of this community and have maintained just the best feeling about the place and the people since then. So there's lifelong connections, and I suggest to you that you really should be aware and value what's happening now as you make the friendships here. They're going to last your lifetime. I'm 76 now. The people who I met there are unfortunately dying off, but they've been one of the best parts of my life, besides Peggy there. But she knows them too. Enough said. The sequence of people who have provided hospitality here, provided leadership, provided inspiration, goes on, and no one could be better. So, texts. Let's start with the text. Life proves pretty fast. If you don't stop and look around once in a while, you could miss it, which, as we know, is from F. Bueller, a raconteur. This, I think, sums up the notion of paying attention to what benefits and blessings you've got. And you have them from the place as well as from the university. I started practicing law in '76 after I clerked not in D.C., but in Hartford, in the district court there for Judge Clarie. And I started with a firm called Tyler, Cooper, Grant, Bowerman, and Keefe. Tyler was Morris Tyler, who was Guido Calabresi's father-in-law, and Keefe was Donald Foran Keefe, who always sat in the front 2 rows in the chapel, had been to double Yale, the college and the law school, and was about as patrician as an Irish guy can get. connection that he had with St. Thomas More was for him a lifelong thing too. So he hooked me up and inveigled me, or no, he ordered me to represent the Hospital of St. Raphael in connection with a Teamster petition to represent the skilled maintenance employees. And that's the painters and plumbers and mechanics and people like that, some of whom have licenses and some who don't. And he started with a reminder that Catholic social teaching includes the right to unionize, and that's something that the hospital was aware of and turned out to be true. But the question legally at that point was, is a skilled maintenance unit appropriate for bargaining? Because when the NLRB decides whether to conduct an election, it decides to do so only if under its criteria the unit is appropriate. And so we went ahead and had a hearing. And it was in this context. The nonprofit hospitals had been made subject to the NLRA in 1974. And so this was 76, and there was a tremendous ferment because there were all these unrepresented people who weren't paying union dues, and the unions were vying to enroll them. And it was very active. But there was legislative history in which Congress said that the board should avoid the undue proliferation of units. And most of the decisions of the board said that a separate skilled maintenance unit was not appropriate. There was, at the time we did it, there might have been two that said that they were appropriate, and there were 11 or 12 that said no. So we had a hearing. The regional director approved the separate unit. There was an election. The union won because they were pretty much unopposed. The hospital considered but rejected the idea of challenging the unit. And we bargained a labor contract instead and had a peaceful relationship until 2012 when St. Raphael's merged into Yale New Haven. But that wasn't the end of the issue. In the next year, at the Second Circuit Court of Appeals, Judge Friendly wrote an opinion that talked about there being irreconcilable NLRB decisions. They provided, in his term, no ascertainable standard for figuring out whether a maintenance unit would or should be approved. And so he said, no one really knows how the board would decide any case in this area of the law. And the decision in the peculiar context of that case was to send it back to the board to try again. But eventually that issue was resolved starting in 1987 when the NLRB, issued the rulemaking on what the only appropriate units would be in a hospital. So today, there are splits of authority like that at the NLRB, but they don't occur the same way they used to. It's not because you have different composition of the panels. It happens because of change of administration. And the president gets to appoint the members, also gets to appoint the general counsel, and when those changes occur, there's wholesale, in recent years anyway, wholesale attempts to, excuse me, try not to make too much noise with this. Wholesale attempts to revise what everybody else has done before. So, an example, and this was one that Jen wanted me to address to some extent, is our graduate assistants employees under the NLRA. Well, this is a brief look at the history. 1970 was the first time that the board asserted jurisdiction over private colleges. In 72, it said graduate workers are not employees for purposes of including them in a faculty unit. So they're not members of the faculty. The next year in the Stanford case, they said, and they're not employees at all within the meaning of the statute. So that's 74. In 2000, it said, whoa, they're statutory employees. And so in NYU, the graduate students could organize because they were covered by the Act. In 2004, they said, no. Now, if any of you is following along on a calendar, you'll see that there are some presidential elections in between these things. So Brown overrules NYU, says the graduate students are not statutory employees. 2016, Columbia says, yes, they are. And that case even allowed there to be some undergraduates considered for unionization. What happens next after the next election? Well, the NLRB in 2019 proposes a rulemaking that would say, no, they're not employees. And because of what was going on, in the next election, they withdrew that rulemaking. Now, notably, and it's no coincidence, no cases got to the board in that interim period when the Trump appointees could rule on whether to overrule Columbia. The unions were very smart in how they approached it. And once the new Biden people got in, the coast was clear. So I'm not sure how many of you are in it, but you've got a union now, and God bless. That's the law of the moment. But it raises a question, and I'll stop with the law stuff because I want it to be accessible for those of you who are not at the law school. There's something called Chevron deference or deferral, in which a court will generally defer to an agency's interpretation of a statute that it enforces. And that's done with respect to the NLRB's interpretation of the National Labor Relations Act. The question which I think is going to be raised in the near future, if not long term, is will the courts of appeals especially continue to defer to the NLRB's interpretation in as much as the interpretations on the same indistinguishable issue continually change back and forth. And it'll be interesting to watch. But let me talk to you about some of the stuff that happened to me in practicing labor law out there. Saturday morning, I get a call from the guy who owns a manufacturing place in New Haven. And he says, George, you gotta help me. I'm at my girlfriend's house. My wife doesn't know. And the guys are out front picketing. And what had happened was the employees are on strike, and they found out where Charlie was with the girlfriend, and they got their signs, and they went out and they picketed in front. I think it was an apartment building too, and they had his name and they had the name of the company, and it was a mess. And I said, Charlie, let me look into this. let me figure something out. And so I went to the office, and there was at that point on the books in Connecticut a law that said it was prohibited to picket a private residence. Blatantly unconstitutional statute. It was later nullified, but at that point it existed. And so I called him up and I said, Charlie, you know, we got something here if we can get anybody to pay attention to it. And he said, well, I sneaked out the back way, and I don't think they got a picture. I was afraid they'd get a picture and send it to my wife. But I told him I would go and talk to the guys. And the guys were, now this is maybe early December. It was dark. There were snow flurries. The guys were down an alley by the manufacturing plant, and they had a 55-gallon drum, and they were burning 2x4s. And so I drove over there, and I had a copy of this statute. And as I parked, it dawned on me that I might be in some danger here. I mean, these guys didn't seem particularly dangerous, but I was not exactly the most impressive person for them at that point. So I walk up, and the biggest, baddest foreman of them all was there, and I said, well, I need to speak with you. You know, what you did to Charlie, that's wrong, and it's illegal. And so the guy looked down on me. He said, "Let me have that." So I gave it to him. I thought he was going to throw it in the 55-gallon drum, and instead he kind of holds it up and he says, "Gee, we didn't know that. Thanks. We'll stop." So I considered that kind of a miracle, and it was one of those things you remember. I represented a company that sued one of its employees for taking bribes. He was a buyer, and he took probably $5 million in bribes. And the company thought maybe they'd been overpaying for the stuff that he was buying, which was a pretty good conclusion. But what they made was paperboard. It's the product that cereal boxes are made of, and they made it from almost entirely recycled material. And so they would get these enormous bundles of cardboard, of corrugated cardboard. And so there was a yard full of it. And one of the things about being a labor lawyer is you get to go to these factories and see how they operate and see this great machinery. Sometimes smell some very bad smells, but this was the place that I saw them taking the cardboard and sending it up a conveyor belt to be dumped into the top of like a 50-foot tall wearing blender. And there was a thing spinning around slowly, and it was this gray muck, and it was kind of like a Gothic novel with the mist coming over the moors, and it was one of those scenes that if I ever write the mystery book, you know, it's going in there. That's where they're going to dispose of the body. But it was just one of the memorable things you see. I won't bore you with too many more of these, but there is one. I represented a guy who bought a belts and suspenders company down in New London, and there were a number of problems to overcome, which we managed, and so he owned the place. And it was organized by still at that time it was called the International Ladies Garment Workers Union. And so we had to negotiate the contract terms with the ILGWU. And I got to meet this character out of Damon Runyon. And his name was Frank Trykowski, and he had a cigar that never left his mouth or hand. I don't know if he ever lit it. And he was the perfect representative of the archetype unreconstructed communist from the 30s. But he was the nicest guy in the world. And we reached a point where we were not in agreement on the contract. And I had made what my guy thought was the last move he had to make. And we went back and forth, and Frank wasn't buying it. And I said, "Frank, at some point you're going to have to take it or leave it." And he was much more mature in the industry than I was, and he had done, hundreds more contracts than I had. And he looked at me, and he just shook his head, and he said, George, you never say that. You say a thing like that, it puts both of us in a corner. And that was some of the best advice I ever got. I was always very grateful to Frank Tchaikovsky. I'm going to skip some of this. St. Raphael's once won an election in which they really campaigned by having the president, who was a wonderful, saintly woman, walk around and talk to people and not talk about the Union at all. She just asked them about their families. She knew all their names. But 1199, which is a pretty aggressive union, was there. And after they lost, the local independent newspaper asked them, well, why did you lose? And the guy said, his complaint was, St. Raphael's is not a rat hole. And I also resisted the temptation to get my photo taken with the rat. But for those of you who don't know, the giant inflatable rat is a prop that the unions use when they're protesting alleged bad behavior by the employer, and it's a lot of fun. Catholic social teaching. The United States Conference of Bishops is in agreement with President Biden, at least on one thing, and that is that work has dignity, as he said in the State of the Union address. It's more than a way to make a living, the social teaching says. It's a form of continuing participation in God's creation, and they have basic rights laid out in the bishop's statement. The right to productive work, the right to decent and fair wages, the right to organize and join unions, the right to private property, and the right to economic initiative. I raise those because they are guidance that we have. If you go onto Google and you Google Catholic social teaching, one of the things you find is that nobody seems to agree on how many principles of Catholic social teaching there are. There's one site that says there are 4. There's one that says there are 8. There's another that says there are 10. The Canadians say there are 11. I'm sure there were some other ones as well. But there's a couple of easy sources. One is the bishop's statement. The other is a 2004 compendium that was commissioned by St. John Paul II, and I'll show you a bit of that later because I think it is a helpful viewpoint of some things that relate directly to collective bargaining. Employment law myths. Management lawyers hate unions. Well, it's not really true. Would we be able to make any money at all if we didn't have unions? But that's not the reason. What this comes from is that there were law firms that used to basically market on the notion that they hated unions more than the other guy. And even they have given it up now. The most aggressive have kind of toned that down. Union and management reps dislike each other. Actually, some of the people I enjoy most are union side representatives. I taught a labor relations course at the UConn Public Policy School for several years, and I always brought in Danny Livingston from the State Bargaining Coalition and some other union side lawyers to talk to the class. And Dan Livingston is one of the really impressive people. He's got a sort of running stand-up comedy routine, but but he was on a picket line before he could walk because his parents were union organizer types, and they carried him around. So he's got a pedigree to conjure with. So they actually do have pretty good relationships, but both sides are a little wary about showing it in front of their clients. I was once hired to represent a hospital in New York in its bargaining with 1199 because the board of directors decided that the prior lawyer was too close to the union. And it was ridiculous, but that really does happen. Employers want to find ways around the law. That we hear that a lot. That's not what I've found. I found that they're really asking for clear guidance about how to comply with the law rather than circumvent it. But they're frustrated by what they find in many cases as contradictory directives. And there's an area of law where workers' compensation and the Americans with Disabilities Act and the Family Medical Leave Act all intersect. And that's one of the most difficult ones for HR people and other decision makers and employers to deal with. And they're looking for direction. I'm from the government, and I'm here to help you. That's something that does vary depending on which administration is in power. But there used to be a practice from the Labor Department of giving advice when employers would request it about wage and hour issues. And they no longer do that, at least not in this administration, and that's a problem. There used to be more rules with safe harbor provisions where an employer could know that if they did something a certain way, they were not going to be sued for it or successfully sued for it. Those are often removed. An exception is the Connecticut Department of Labor, where they do give you notice of what their enforcement positions are. You can't work both sides of the street. You can't work for unions and employers, and that's pretty much true. The two sides don't play well together. So if I hang out my shingle, I'm not going to get both unions and employers at my door. But people can do work for employment cases, for plaintiffs and for defendants. And some of the most enjoyable and rewarding cases that I had at my old firm were for some individuals. One of whom sued Yale, which was great fun. We deposed Bart back in the day. So you need to contend with conflicts in order to be able to do it. But doing a plaintiff's case really teaches you how to defend the cases and what mistakes not to make. Okay, so the compendium, the 2004 compendium, talks about subsidiarity. And I find this a very interesting concept that when I was doing my research for Jen, I found out about. And what the social teaching on this tells us is that decisions should be made as close to the people affected as possible and to the extent possible by them. And that the role of the federal and state governments is one of supporting the activity of decision making at the low level. And it strikes me that collective bargaining and the determination of what contract terms are going to be and what the working conditions are going to be is a very good example of subsidiarity. So one of the ways in which in retrospect, I realized I was implementing Catholic social teaching, was in reaching those conclusions, the agreements. One of the most satisfying things you can do is conclude a difficult contract negotiation with a union, because there's no appeal once it's over. It's signed up. I mean, I've won jury trials, and I knew it was likely there'd be an appeal afterwards. But you sign up the memorandum of agreement that records what you've decided in the collective bargaining, and it's over. You can breathe a sigh of relief and put the file away. I'm just going to go over some of the, how are we doing on time? Okay. Let me run through some of the drama and rituals that typically occur in bargaining. But before I do that, what I ought to say is, as those of you who are following the bargaining for the Graduate Assistants Union get increasingly interested in what's going on, don't expect it to be over fast. I had the privilege of bargaining UConn's first contract with its GA union, and it took us over a year. It's a very complex thing, and it's more complex than most, in part because of that question of how do you distinguish between the role of student and the role of employee. Everybody in the faculty has an opinion that they are telling to the people who are going to be at that table, and they are not always consistent opinions. The rough outline I'm going to give you will happen, but it'll take a long time. And the union is going to be more energetic, creative, and inventive than I'm allowing here. I'm sure it's going to be tumultuous and fun at the same time. But if you start off, everybody's got a poker face, particularly the people on the union negotiating committee, and they don't respond, and they don't interact. There's this sort of feigned hostility, because you got to know you're not getting through, and then there's choreographed speeches in which the chief negotiator is often denounced. And I was at one time when we went out of the room to caucus, we came back in, and the management table had been moved 10 feet away from where it had been before. But that kind of initial play acting, everybody sort of understands. In the middle of things, the mood kind of loosens, you get used to each other, you've got the folkways going, people are teasing each other, the groups are having communal meals, and it is sort of ritualistic. And then there'll be complaints of delay. It doesn't matter what's happened, there'll be complaints that there's delay. And then there's PR stunts, and that will be both ways. There'll be public relations events from both sides in many circumstances. And there's union usually starts targeting higher-ups, either for criticism or trying to get them involved so they will override the people at the table. When you're approaching the end, this is a drama that's going on. So you need a crisis. You need angst, and because what's the point of resolving it if you don't have stuff like that? So people start making signs, on strike signs. There's strike discussion. There's preparation for the strike. In the hospital context, people to fill in for the employees are being hired, and there's a healthcare strike notice that's required. And then at the end, I'm thinking here of a big contract. There's often an overnight session, at least on the last day, but possibly before then. And the cavalry arrives. And what I mean by that is sometimes the people at the table can't make the last calls that are necessary. Most contracts get settled in the last tough issues by there being two people in the room, or two people doing the talking and one person along with each one. But the union in New York that I negotiated with, the second or third time we did it, the guy who was the new executive president or vice president came in, and he was the only one who could talk them into the settlement, and I was the only one who could get the chairman of the board to overrule the CEO who didn't want to do what we needed to do. So that somebody has to kind of make the tough calls. Then there's hugs and smiles. I mean, it really is this great sweetness and light. Everybody's so relieved they don't have to use the darn signs, and that they are not going on strike. And then you type the thing out because you don't let it molder. And as the sun is coming up, you're proofreading it and you sign it up before you go home. That's kind of a broad outline. But what could go wrong? Well, sometimes strikes are unavoidable, and you shouldn't have one without both sides having an exit plan. There are some unions that need to have a strike as part of this process, and it's usually a planned 2 to 3 day strike, and both sides know it's going to happen because the union needs to get the deal ratified, and often to get enough votes to ratify a deal, you have to show you've been tough and you've held out. And so sometimes there's that. And then there's questions about replacement workers, because if the hospital, for example, has hired a week's worth of nurses to replace the nurses who are threatening to go on strike, you pay that up front. And so sometimes it goes wrong because if you have to bring them in, they stay there for the week generally. There's a loss of benefits to strikers. There's unemployment complications. But you need to remember the people throughout this, that you're not going to lose them. I mean, there's a possibility of doing permanent replacements within the realm of the law, but that's not how real employers with a sense of conscience do it. They know that these are employees you're going to be working with down the road, and you can't cut off relationships. I'm just going to mention that you guys are going to face the artificial intelligence world, and it was originally welcomed by employers because they thought we can avoid these discrimination and retaliation claims. Because what we can do is we can program this so we don't have a human being making these decisions or these culling of resumes, and we'll avoid all those claims. That didn't work out so well. That hasn't prospered. The reaction from the folks who watched how the AI devices were being used is if the data set that goes into them is questionable, if it is somehow replicating prejudices or replicating proxies for the prohibited characteristics, then you've got just as much of a chance of being sued, and maybe more, because it's trackable. So right now, employers facing this are proceeding with caution, and my advice to people is, if you don't need to use the AI stuff for a particular task, maybe at this point it's better not to do it. The other thing you guys are going to face, and I assume that many of you are going to be either employees or employers and maybe managers, one of the questions is, who's going to be managed by a machine? And there have been some great articles about the sales representatives who are at this point already being managed by computer programs, which give feedback that sometimes is good and sometimes is ridiculous. And there was a woman interviewed recently in one of those stories who said, I can tell somebody, and then she used some very bad words, as long as at the end of it I lilt my voice up, and because the machine likes that. So you got to watch this stuff. You guys are likely to encounter it in ways I never will. 20 years of schooling and they put you on the day shift. That's Nobel laureate Robert Zimmerman. You're going to have work to do one way or another as employee or employer when you get done with whatever you're studying now. I think maybe we're at a time to break this off, but let me. What I had done was I had put in some suggestions about how you negotiate things, and there is a general prudential rule that I learned about from my friend who was a Navy veteran and a boater down in New London, and he told me that there's a general prudential rule of seamanship, and I commend it to you as you go through life and your work life. If you are in a sailboat and you have the right of way over this thing, don't take it. I think that what you ought to do, and I cribbed this from a Facebook post that Sister Jen had up. To love is to will the good of another. It's Thomas Aquinas, saint and sage. Those are words to live by. They'll serve you well wherever. Thanks for listening. What do you want to do now?
Thank you, George. I realize we had a late start, so I know students, if you need to study, feel free to step out and do that. I have a question to start with, and then if other students want to come up, feel free to do that. I know you work for several Catholic organizations or have in the past. I'm wondering if you've seen Catholics being leaders in some of the labor law and how to be the most just employees, or if there's places you know that they could still work towards.
I think that Catholic institutions approach labor issues in very different ways. There are some special concerns, and they deal with them differently. LGBTQ situations, health insurance situations, what's covered and what isn't, what you say is scandal versus what you don't. But I'll give you one example. The health insurance coverage of same-sex partners, some Catholic institutions have no problem providing that, although very often what they will do is provide the coverage for 2 adults in the household, whatever the relationship, so that it could be brother and sister or an adult child. And it never raises the issue of, who's got to be married and is this a marriage that we represent. I think that by and large, the Catholic employers I've dealt with have always had a component of moral uprightness in the decisions that they make. There's differences of opinion on what that involves. If you are the president of a Catholic college, you get letters every week telling you that you're the spawn of Satan and that somebody read in some newspaper about what some faculty member did and how can you allow them to be there. So you got to put up with that, and figure out which of those might have a kernel of truth and which don't. I don't know that I can generalize because I think it's very specific. If you want me to blather on, I can, but I've been very impressed by the sincerity and the goodness of the leaders of the Catholic institutions that I've been fortunate to represent.
Hello.
Hello.
I'm just going to project. Hi, I'm Paul. Thanks for speaking. So I'm at the law school, by the way. So anyway, my question for you is about the subsidiarity point. Like right after that, you went into the dramatics of like how negotiations work. I'm kind of wondering. It sounded like in some moments, it may have just been because it was brief, but it sounded like in some moments that there's a disconnect between the union leadership and representation and like the people out on the line, right? Like you said, you have to strike because otherwise people are going to be upset. And I'm kind of wondering what role the like everyday lower, like on the totem pole workers get in all of that process, and if they feel like they're heard and that sort of thing.
Well, the key to a lot of this is communication, and a good bargainer on behalf of a union is going to make sure that people are kept informed, maybe not of every proposal that's made and every counter, but they'll be kept informed of the progress of negotiations. And the union's not going to take anybody out on strike unless they believe that the vast majority of the bargaining unit will do it. I mean, if people cross the picket line, the strike falls apart. So they have meetings. They often send newsletters. I've been involved in negotiations where at the end of each session, each side put together a summary of what occurred and sent it to their own constituents. So I think that there may be some other union leaders that don't have as good communications as I just described, but I think the best of them do.
Thank you.
This is my cue.
George, thank you so much for joining us tonight. And I realize if Catholic guilt works this well, then I can probably ask all of you to do things, right? So, so thank you for coming and just being part of this community. It's wonderful to have you here and joining us tonight for this particular topic. And thank you all for joining us. And we'll have another lecture right after Easter. Thanks.